Chief Justice Jayanta Jayasuriya emphasizes that according to the Constitution, the judicial power of the people is exercised by the Parliament through the courts. He notes that the direct exercise of this power by Parliament is limited to its own powers and privileges and those of its members. In a letter addressed to the Speaker, Chief Justice Jayasuriya highlighted the responsibility of all sectors to protect and ensure the independence of the judiciary, essential for the proper exercise of judicial powers. Translated excerpt from the letter. The independence of the judiciary is recognized as an intangible heritage that guarantees the pride and prosperity of future generations of Sri Lankans and the global community. The Constitution declares Sri Lanka's commitment to being a democratic socialist republic. End of translated excerpt. Chief Justice Jayasuriya further stressed that mutual respect and restraint between the Parliament and the judiciary are crucial to protecting public welfare and upholding the rule of law. On the 19th of June, Minister of Justice Dr. Vijayadasa Rajapaksa raised several issues related to the judiciary in a statement to Parliament. These included an interim order by the Supreme Court concerning the appointment of Supreme Court judges excluding the Chief Justice, opinions on interim orders by the Colombo District Court relating to the Sri Lanka Freedom Party. The Justice Minister in his statement to Parliament levelled strong criticisms at the current Secretary of the Judicial Service Commission. In response to the Minister's statements, the Judicial Service Association representing district judges and magistrates issued a statement on the 24th of June. They condemned the Minister's irresponsible statements and warned of a concerted effort to discredit impartial judges. On the 25th of June, Minister Rajapaksa wrote to the Speaker, claiming that his privileges were violated by the Judicial Service Association's letter. The Minister, citing two individual circulars, highlighted the limits imposed on the judges when commenting to the media. He requested that the two judges who signed the statement be summoned before the Privileges Committee of Parliament. He made the request by letter, copied to the Attorney General as well. Chief Justice Jayasuriya addressed the issues raised by Minister Rajapaksa in a letter to the Speaker on Monday. In addition, the Chief Justice, as the Chairman of the Judicial Services Commission and its members, Supreme Court Justices Vijit Malalgoda and EAGR Amarasekara, had signed a letter as the Judicial Services Commission and directed separate observations to the Speaker with regard to the concerns raised by the Justice Minister. Chief Justice Jayasuriya, responding to the claims made by Dr. Vijayadasa Rajapaksa over the appointment of Supreme Court justices, noted that the two vacancies in question at the Supreme Court occurred on the 15th of November 2023 and 1st of March 2024. Chief Justice Jayasuriya clarified that the interim order on the Supreme Court appointments was issued on the 30th of April 2024 and there were no legal obstacles to filling the vacancies between the 15th of November 2023 and 1st of March 2024. He also stated that the appointment of the 5 vacant Court of Appeal judges could proceed without issue. Translated excerpt from the letter. There was an error in the Honourable Minister's statement naming the Honourable Colombo District Judge regarding orders in an ongoing case in which the Minister is a party. Standing Order 91E applies to statements made in Parliament regarding existing cases. End of translated excerpt. The Judicial Service Commission in its letter to the Speaker emphasized that the Judicial Service Association's press release was based on official matters. They noted that the circular cited by the Minister warned against harming the independence and dignity of the judiciary through media statements. The Commission affirmed their confidence in the Secretary of the Judicial Service Commission, stating that he had not misused any rights or privileges.
The Minister of Justice, who initially raised concerns about privilege violations outlined in the letter addressed to the Speaker, has now withdrawn the original proposal to refer the 2 judges from the Judicial Services Association to the Privileges Committee.
I
have not fully studied the document submitted by the Judicial Service Commission. I will study it and provide further clarifications if necessary. I have submitted my question of privilege to summon the 2 judges who issued the press statement to the Privilege Committee. However, Honorable Deputy Speaker, since the Judicial Service Commission has already responded to this matter, I am not making such a request at this time. But in the future, I ask for your permission to consider these investigations and measures if necessary. I am not making the request that they should be summoned at this time.
මාස පහමාරක් තිබිලා තියෙනවා. ඒතර මාස
It has been 5.5 months, and during this time the government has failed to fill the 2 vacancies in the Supreme Court. We too have a problem with the interim order, but the issue lies not with the interim order because it has been a long time since these vacancies existed, yet the vacancies were not filled. The responsibility of this delay does not rest with the Secretary of the Judicial Service Commission but with the government. It is very serious that the blame is placed on the Secretary of the Judicial Service Commission after a district judge issued a verdict against a case that was filed by the Minister of Justice. The Secretary of the Judicial Service Commission will not obey the orders of any politician and will not act on those needs. That is the issue here.
ඒක තමයි මේ රිදිලා තියෙන්නේ. විශේෂයෙන්ම පෞගිය කාලේ ජනාධිපතිතුමාට පක්ෂව තීන්දුව දුන්නාම අධිකරණය එතකොට අධිකරණයේ ස්වාධීනත්වයේ තියෙනවා. ජනාධිපතිතුමාට විරුද්ධව තීන්දුව දුන්නාම අධිකරණයේ ස්වාධීනත්වය.
In the past, when the judiciary ruled in favor of the president, it was said to have independence. However, when it ruled against the president, its independence was questioned. The then term judicial cannibalism is used. This reflects President Ranil Wickremesinghe's policy towards the judiciary. Now the match is ready to be played, but the president is trying to avoid participating directly. Instead, there are attempts to influence the proceedings. We urge the president to play fairly, not act as an umpire, and certainly not to manipulate the outcome through methods like the Duckworth-Lewis method in cricket. We urge the government to cease the undemocratic methods and stop influencing the judiciary by deploying their pawns.
අධිකරණයට තමන්ගේ ඉත්තන් යවලා තමන්ට අවශ්‍ය දේ අධිකරණයෙන් කරගන්න බලපෑම් කරන එක නවත්තන්න.